Every keystroke, every private message, every location ping from a company-issued device is being silently funneled into a massive corporate database. This is not a hypothetical future scenario, but a present reality authorized by a gaping legal loophole that strips away digital autonomy the moment a worker logs in. The modern workplace is transformed into a panopticon where the boundary between professional oversight and invasive surveillance has completely collapsed. The foundation of this massive data harvesting operation rests on the company property doctrine, a legal principle dictating that employers possess absolute authority over the devices, networks, and systems they provide. When an individual uses a corporate laptop or connects a personal phone to a company network, they effectively surrender their expectation of privacy. This doctrine treats digital communications not as personal correspondence, but as corporate assets subject to unrestricted search and seizure by the employer. Under this legal framework, companies deploy sophisticated digital forensics tools to monitor employees. These systems track idle time, log internet activity, capture screenshots at randomized intervals, and even activate webcams without explicit warning. The software operates stealthily in the background, continuously aggregating behavioral data to create comprehensive profiles of an individual's daily habits, all legally sanctioned under the guise of protecting company assets and ensuring productivity. The consequence of this relentless tracking is a profound erosion of personal digital autonomy. Workers are forced into a constant state of self-censorship, aware that a seemingly innocuous internet search during a lunch break or a hastily typed message to a spouse is permanently logged. This environment replaces trust with suspicion, fundamentally altering human behavior and creating a chilling effect on free expression within the digital spaces where people spend the majority of their waking hours. At the federal level, the primary statute governing these digital interactions is the Electronic Communications Privacy Act, commonly known as the ECPA. Enacted in 1986, this law was originally designed to protect wire, oral, and electronic communications while they are being made, in transit, and stored on computers. The Act prohibits the unauthorized interception of these communications, theoretically offering a robust shield against unwarranted domestic surveillance. However, the ECPA contains massive exceptions that effectively nullify these protections within the workplace. The most heavily exploited is the business purpose exception, which allows employers to legally intercept employee communications if they can demonstrate a legitimate business reason for doing so. Because courts have historically interpreted this exception with extreme leniency, almost any form of monitoring can be justified as a measure to prevent data leaks, ensure quality control, or evaluate employee performance. The secondary mechanism dismantling federal protections is the consent exception built directly into the ECPA. Employers routinely embed sweeping surveillance authorizations within massive onboarding documents, employee handbooks, and mandatory acceptable use policies. By simply signing these documents or logging on to the corporate network, workers provide legally binding consent to be monitored. Often, without fully comprehending the immense scope of the data collection they are authorizing. Through these dual exceptions, the federal shield is transformed into a weapon of corporate oversight. The very law intended to safeguard digital privacy now provides the legal scaffolding for comprehensive workplace surveillance laws. Employers are granted unchecked authority to vacuum up massive quantities of sensitive information, operating entirely within the bounds of federal law, while systematically dismantling the fundamental right to digital privacy. This vulnerability has reached critical mass with the widespread adoption of remote work and bring your own device policies. When the corporate office relocates to the living room, the boundaries of employer surveillance expand into the most intimate spaces of personal life. Monitoring software installed on personal devices to access company networks can inadvertently capture private banking details, medical appointments, and location data outside of working hours, blurring the line between professional oversight and domestic intrusion. The sheer volume of information collected through these legal channels is staggering. Employers are no longer simply tracking typing speed or application usage. They are engaging in complex data aggregation, the process of compiling disparate pieces of digital information to form a holistic, highly predictive profile of an individual. This aggregated data can reveal deeply personal insights regarding an employee's health status, political affiliations, and financial stability, far exceeding the scope of any legitimate business need. Without stringent federal boundaries, the American workforce is left exposed to a geographic lottery regarding their digital rights. The absence of comprehensive national employee privacy rights means that an individual's protection from invasive monitoring is entirely dependent on the specific state in which they reside. This fragmented legal landscape creates a massive vulnerability, leaving millions of workers completely defenseless against predatory data harvesting practices simply because of their zip code. In response to this federal void, a handful of jurisdictions have attempted to establish localized safeguards. State-specific employee privacy laws, such as Connecticut's notice requirement, mandate that employers provide clear, written disclosure to employees prior to implementing electronic monitoring. These statutes are designed to pierce the veil of silent surveillance, ensuring that workers are at least aware of the digital crosshairs trained upon them. Yet, even these state-level protections often provide merely an illusion of security. Notice requirements compel transparency, but they rarely restrict the actual scope of the surveillance being conducted. An employer in Connecticut must inform their staff that every keystroke is being recorded, but the law does not prevent the employer from continuing to record those keystrokes. The burden is simply shifted to the employee to accept the terms or face potential termination. In states lacking even these basic notice statutes, the surveillance operates in total darkness. Workers in these jurisdictions can be subjected to continuous audio real-time screen mirroring and GPS tracking without ever receiving a single warning. The legal silence in these regions empowers corporations to deploy the most aggressive forms of digital monitoring, treating human employees as untrusted nodes in a proprietary network. Despite this bleak landscape, workers are not entirely without legal recourse. A surprising defense against pervasive monitoring emerges from a law passed nearly a century ago. The National Labor Relations Act, or NLRA, originally designed to protect the rights of employees to organize. This foundational labor law has become a critical tool in the modern fight for digital autonomy, offering protections that extend far beyond traditional union activities. The NLRA explicitly protects the right of employees to engage in concerted activities for their mutual aid and protection. This includes the right to discuss wages, working conditions, and potential unionization efforts with coworkers, whether those conversations happen in a break room or over a digital messaging platform. If an employer uses surveillance software to monitor, intercept, or chill these legally protected conversations, they cross the line from legal oversight into federal labor law violation. Recent enforcement actions have modernized this protection for the digital age. The National Labor Relations Board has explicitly warned that the use of automated management algorithms and electronic surveillance to track employees can violate the NLRA if it interferes with their right to organize. This interpretation transforms a labor statute into a powerful data privacy shield, providing a verifiable legal mechanism to challenge overreaching corporate surveillance. To leverage these protections and reclaim digital autonomy, individuals must implement strict compartmentalization strategy. The most effective defense is absolute physical and digital separation between professional obligations and personal life. Never conduct personal business, access private email accounts, or handle sensitive financial data on a company device. The moment personal data crosses a corporate network, it becomes vulnerable to the company property doctrine and the sweeping exceptions of the ECPA. Furthermore, workers must ruthlessly audit their digital environment, review the acceptable use policies and employee handbooks signed during onboarding to understand the exact scope of the consent provided. If a personal mobile device must be used for work, refuse to install comprehensive mobile device management profiles that grant the employer root access to the hardware. Demand alternative solutions, such as secure containerized applications that restrict corporate access exclusively to work-related data. When utilizing personal devices in a remote work setting, strictly avoid connecting to a corporate virtual private network for personal browsing. A corporate VPN routes all internet traffic through the employer's servers, effectively bypassing home network security and delivering personal browsing history directly into the hands of the company. Maintain a dedicated, isolated network for personal devices to ensure that corporate monitoring tools cannot bridge the gap into domestic spaces. The urgency of implementing these defenses cannot be overstated, as the nature of workplace surveillance is rapidly evolving. Companies are increasingly integrating artificial intelligence to analyze the massive data sets harvested from employees, shifting from simple monitoring to predictive behavioral modeling. These algorithms attempt to quantify employee sentiment, predict retention rates, and flag potential dissent, creating a dystopian environment where an individual is constantly judged by an opaque digital metric. This algorithmic oversight introduces severe risks of automated discrimination. If a surveillance system disproportionately flags employees who require medical accommodations for taking longer breaks or penalizes workers discussing legally protected labor issues, the technology becomes an instrument of illegal bias. The threat is no longer just the loss of privacy. It is the automated enforcement of corporate compliance at the expense of civil rights. The unchecked expansion of this legal loophole represents a fundamental crisis for digital autonomy. When the laws designed to protect communications are weaponized to facilitate mass surveillance, the concept of a private digital life is severely compromised. The workplace should not require the total surrender of constitutional privacy expectations. Yet the current legal framework heavily incentivizes corporations to treat employee data as an infinitely exploitable resource. Blocking this vulnerability requires vigilant awareness of where legal protections end and corporate authority begins. By understanding the severe limitations of the ECPA and the specific protections offered by the NLRA, individuals can navigate the modern workplace with informed caution, recognizing the signs of illegal surveillance, such as monitoring, protected labor discussions, or failing to provide mandated state-level notices, empowers workers to challenge corporate overreach through appropriate legal channels. Take immediate action to secure your digital perimeter. Audit your devices, segment your networks, and retract any unnecessary permissions granted to corporate applications on personal hardware. Do not rely on the assumption of privacy in any environment controlled by an employer. The only guaranteed method to protect personal data from workplace monitoring is to ensure it never enters the corporate ecosystem in the first place. The legal loophole allowing extensive employer monitoring of employee data remains wide open, feeding a multi-billion-dollar surveillance industry at the expense of individual rights. Until federal legislation is enacted to establish definitive boundaries on corporate data harvesting, the responsibility for defending personal autonomy falls entirely on the individual. The invisible network is always watching, but informed vigilance is the ultimate countermeasure. We must recognize that the digital tools provided for productivity are simultaneously instruments of surveillance. The battle for privacy is fought daily on our keyboards and mobile screens, requiring a proactive stance against the continuous erosion of our rights. Protect your data, enforce your boundaries, and refuse to surrender your autonomy to the corporate panopticon. Follow for more legal clarity.